Hello everyone, Derek Johnson with Tatango.com, and today we are answering TCPA questions from the internet. So luckily today I have a TCPA attorney with me named David Carter. The question the internet needs an answer to, David, is will RCS be covered under the TCPA?
Well, that's an interesting question, Derek, and as you know, the FCC, which is the agency that regulates the TCPA, has not yet weighed in on this specific question.
Okay.
But they have weighed in on the question of whether text messages are subject to the TCPA. And that decision from the FCC has also been looked at by the courts and confirmed. And we know that text messages are subject to the TCPA. And so the question I would have for you as someone more in the technology space is, how does RCS differ from text messages?
Yeah, no, it's a great question. I think what the carriers and the handset manufacturers have done is they really want it to appear in the same place as SMS, appear like an SMS, but then have just additional functionality and features such as, you know, buttons and high definition images, and you can swipe through more like an app-like experience. But it's very clear, just like with iMessage, RCS, they don't want you to have to download another app. They don't want you to have to go somewhere else to see these messages. They're almost intertwined into your regular messaging, because that's, I think, where all the adoption will come from. If you have to go somewhere else to get an RCS message, no one's going to go.
Right.
But because they're so intertwined, I'm interested to hear, is that, you know, so in the TCPA, actually in the original TCPA, they don't even mention text messaging.
That's right.
Okay, they mention what? Calls?
Calls and faxes.
Faxes,
is there,
okay,
right?
okay.
Yeah.
You might have to explain to me that later, what a fax is. And then later on, they clarified and essentially kind of tacked it on, right?
Well, the FCC interpreted the definitions within the statute to also encompass text messages. And said that text messages are essentially a call, and therefore governed by the TCPA.
Okay, so now we're at the point we have text messages, faxes, phone calls, and now we're getting to this kind of like over-the-top messaging. But over-the-top messaging on Facebook and WeChat is relatively different because it's within a different app, it's within Facebook.
Right.
These RCS messages are within your regular text messaging, your native app on the phone. So is this something that FCC is going to have to come out with? Is this something the courts are going to have to figure out? Is it going to increase liability until these things get resolved?
Yeah, so I think as I understand RCS from a technical perspective, that it is in many respects kind of like the WhatsApp messages and other messages that are coming to you using an internet protocol, where traditional text messages use a text messaging protocol. And that's creates this really interesting legal question, probably interesting only for telecom lawyers like myself, but interesting legal question about how exactly the FCC will look at this issue. And so I would say that from the perspective of a brand and a company, when they're looking at this, until the FCC makes some affirmative decision and says, if they say definitively that RCS messages are not subject to the TCPA, then you would have that comfort of knowing it. But because of the potential exposure of guessing that an RCS message is not subject to the TCPA, only then to find out later, either through a court litigation or through some FCC proceeding, that in fact it is going to be subject to the TCPA, that companies have to start from the premise of, I should act as though the TCPA does apply.
Because there's such high damages that being wrong would be disastrous.
Exactly. The potential exposure of guessing that the TCPA does not apply and then finding out later it does could really be catastrophic for a company. And so you have to, I think, in these circumstances, because the consumer is going to receive the message in the same program in which they receive other text messages and MMS messages, you have to assume that from a consumer perspective, they're going to think the TCPA applies, and therefore they're going to, if they haven't given the right levels of consent, they're going to bring cases and challenge the use of RCS and whether it's subject to the TCPA.
Okay.
And so you have to kind of start from the premise of, better safe than sorry in this particular circumstance. And I think that, the other thing to keep in mind is that at least in some circumstances, the programs, the RCS texting programs I'm hearing, are going to use traditional MMS or traditional SMS as kind of a fallback or a backup.
If they don't have RCS, it'll go, send an SMS or an MMS message. Yep, you're correct.
So if that's also the case, where if you're trying to get an RCS message to someone, but if they don't have that capability, you're going to do a default
Yes.
to an MMS or an SMS message, then you also have to think about it from that perspective as well, which is, well, I know I'm going to need the affirmative consent and the written consent if it's a marketing message for those alternative backup plans. So therefore, I really have to approach the entire campaign as being a TCPA compliant campaign.
Okay. So really at this point, definitively RCS being covered by the TCPA, until the FCC comes out, we're not going to know.
Correct.
But best practices, it would be best practice to just assume that it's going to be until the FCC comes out and says it's not.
Correct.
Which, do you even have a sense if they will or won't, or will they even address this issue?
Yeah, so I think that you're going to not see the FCC proactively address this issue anytime in the near future, unless there is a petition filed at the FCC where a company asks for clarification or asks specifically for a ruling on this. And even if they ask, they may still have to wait quite some time for the FCC to decide that. So I actually think you will probably more likely to see the first movement on this issue happening in the courts, happening in a place in which someone maybe sends out RCS messages, doesn't have consent, and then someone brings a case, and then you'll start to see the courts address the issue perhaps even before the FCC.
Like the brand would say, hey, we shouldn't be sued because this was an RCS message, and then it'll come up to the court. But as I've discussed with many of your, colleagues, if one judge, in Washington State decides that an RCS does fall under the TCPA, that doesn't mean every judge in the United States follows that ruling.
Correct, right. So
it's still risk, a huge risk.
Yeah, so you could have a favorable ruling in one court in the country and then a bad ruling coming out of another court. And that process and where those decisions kind of percolate up through from the trial courts to the Court of Appeals can take years to get resolved, and that's often what we see. I mean, there's other technologies. If you look at, for example, direct drop voicemail as an example of a technology that has been around probably 8 or 10 years at least, but still there's uncertainty about whether the TCPA applies. And that's not, in my experience in telecommunications issues, it is not uncommon for new technologies to have this period of uncertainty where the FCC in part is looking to see how the technology evolves, how it's used, before they come in and declare a regulatory framework for it. And I think you would see the same thing here potentially with RCS, in which you may in fact have these debates or these fights play out over time. And so the good news is I think companies do have an argument about how it could not be subject to the TCPA, but the practical news is you have to kind of assume it might be that someone will find that it is covered by the TCPA and plan your compliance strategies with that in mind.
Yeah, because the damages, $500 to $1,500 per text message, unless you want to take that risk. And also, it's not that hard to be TCPA compliant. You get people to opt in, you get their consent. It always is a good thing for a brand to get consent. Even if there were no laws on the books, it's horrible to spam your customers.
Right, well, exactly. You kind of want to be communicating. You want to be spending the time and energy communicating with people that want to be communicated with.
Yeah.
And in that way, they're not going to be likely to come after you for litigation purposes, and they're going to get the messages and be happy to continue engaging with the brand around whatever product or services the brand offers. And so in general, you're right, there's little effectiveness when you're just spamming people that are not really looking to receive those messages. But again, from a legal perspective, you have to think about those. Really, it's the exposure and the potential for damages that could accrue if you are found to be out of compliance with the TCPA.
Well, it's going to be a hot topic, and it's going to grow because RCS is going to continue to grow as a platform and as a messaging channel,
Right.
Just like SMS, then MMS, and now we have RCS. So I definitely think it's going to see more and more, but I think you're right. Just follow the TCPA. If you're doing messaging, especially text messaging, anything that's ending up in the native messaging app, that maybe the consumers don't even realize it's RCS.
Right.
Best to follow the rules.
I am sure most consumers don't know what RCS is or how to distinguish it.
As I always say, let another brand, test the law while you remain compliant. Awesome. Well, that is a TCPA question and a TCPA answer from a real live TCPA attorney, David Carter. Again, my name is Derek Johnson from Tatango.com, and we are answering your TCPA questions.